Hello, this is Matt on the Moon Lambo channel. This is video part 2 of my coverage of Attorney John Deaton's amicus brief, although, as I cited in the last video, it's an application to file an amicus brief, but the actual amicus brief is included as an exhibit, so we're actually going through the real thing here. I do want to say at the outset, if you're hearing this is part 2, oh no, if it just popped up, I didn't hear part 1. It's okay, chill. If you want to go back, I'll go ahead and link to my first video in the detail section, but I will say this. Given the way that Attorney Deaton kind of broke this thing down by topic, and the way that this flows, my personal opinion is that if you do jump in here, it's okay to watch this one first, then watch the other one. I don't think it's particularly going to matter. You're going to get all the information. There's not a whole lot of overlap or repeating. It's not necessary in almost every instance to understand what was said earlier on, because there are a lot of standalone points. And if I find any exceptions to that as I'm going through here, then I'll just point out, okay, fine, there is something that was referenced you need to know. I off the top of my head, because I read this whole thing already, I don't recall there being an instance of that other than, I know that the GAO was open, or was mentioned rather, at some point in the second half, was also mentioned in the first half of the amicus brief. Other than that, I didn't really catch anything where you need to have watched the first video. So whatever you want to do, if you want to check it first, totally cool. I will go ahead and put a link down in the description below. It's the very last video that I published before this one, and I'll try and get both of these uploaded as quickly as possible. In fact, as I'm recording this now, what the hell time is it? 3:09 a.m. Central Standard Time on what the hell date is this? Oh yeah, it's November 1st now. Anyway, yeah, so it's now 3:09 a.m. Central Standard Time. And the first part of this, part 1 of this 2-part video here covering John Deaton's amicus brief, is uploading right now. So once I finish recording this, I'll get the thumbnails hammered out and get both of these up for all y'all as quickly as possible. And then I have a whole lot more to cover. We'll see how much I can get to, because there were actually 4 amicus briefs filed. I keep saying today because I haven't gone to bed yet. Technically yesterday because it's after midnight, fine. But 4, including Coinbase. So I intend for my very next video to cover Coinbase's amicus brief, which I haven't even read yet. So I'm about to this all takes some time, though. But I do want to be clear at the outset here, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Okay. So I got my printed up version of the amicus brief here. I'm going to try and remember to scroll down as I'm covering this, because I highlighted a bunch of parts that I wanted to make sure that I do cover here. And we'll be jumping in right here talking about XRP's utility. So XRP's utility and non-investment use is a material fact in dispute. Instead of satisfying Howey's 3 prongs, the SEC asks this court to declare as a matter of law all Howey prongs satisfied because Ripple sold XRP for investment to certain individuals, likely accredited investors, and undertook efforts to promote XRP. Okay, I need to point something out right here, and I've mentioned this before, but I want to make sure everybody understands, or else you're just going to be scratching your head, and that wouldn't be doing you a good service here. So, you've seen, I'm sure, that some people cite that there are 3 prongs to the Howey test. Some people cite that there are 4. And the short answer is typically because some people include 2 prongs condensed down into 1 because they're effectively quite similar. So there's, for instance, an investment of money, so that'd be a prong, 2, in a common enterprise, and then 3, based on the efforts of others, effectively, and with the expectation of profit. And so sometimes those last 2 there kind of get condensed down. That's fine, whatever. It's unfortunate that some people, not everybody's speaking the same language, so this is, I don't know if one's better than the other. I don't really have a strong opinion there. It's just unfortunate that there's confusion, because some people say there's 3 prongs, some people say there's 4 prongs, but it does get a little more hairy than that, and I have to mention this as well. Kim Jong-Gensler, he also says that there are 3 prongs, but not in the same way that Attorney Deaton is citing that there are 3 prongs here. No. Kim Jong-Gensler throws out the common enterprise prong. And why might he do that? Well, my supposition, and I think it's pretty clear that this must be the case, is because if common enterprise isn't a prong of the Howey test, it's pretty much way infinitely easier to satisfy the Howey test, meaning that something is a security. So just throw out the requirement for there to be a common enterprise. No, we're all good. Which is not what Attorney Deaton is talking about here. He's including that. So anyway, I just want to make sure. So hopefully that was clear. Now here's the rest of what Attorney Deaton said on this. The SEC literally asks this court to skip over conducting an analysis of the second and third prongs of the Howey Test. A truly remarkable ask. Even worse, the SEC has failed to meet its burden regarding Howey's first prong. Throughout this case, the SEC has failed to take into account the non-investment use of XRP. While the SEC remains in a stage of perpetual denial, the rest of the world, including the court, accepts XRP's unique utility. Japan, Switzerland, Singapore, the United Arab Emirates, and the United Kingdom have all declared XRP a currency, not a security. And here's a quote from Judge Netburn in this case, as cited here by Attorney John Deaton. Judge Netburn said, "My understanding of XRP is that not only does it have a sort of currency value, but it also has a utility, and that utility distinguishes it, I think, from Bitcoin and Ether." End quote. Exactly. So there you go. Even the court is recognizing that there is actual utility. The SEC just likes to pretend that it doesn't exist. Anyway, and then Attorney Deaton continues right about, I think here. Yeah, there we go. Okay. By asking this court to find, as a matter of law, that all past, present, and future sales of XRP are securities, the SEC wants this court to ignore the millions of times XRP is used each day, as well as ignore all the non-investment acquisition of XRP. The SEC asks this court to disregard companies like TapJets, iRemit, and Spend the Bits, and of course, ignore the nearly 3,000 XRP purchaser affidavits. Exactly. Because if they acknowledge these things, that's an acknowledgement of utility, which again, on more than one occasion, the SEC has explicitly stated they do not agree that it exists. And here are all of these entities saying, well, that's a bunch of BS. Look at this. And they filed amicus briefs. iRemit, TapJet, Spin the Bits, they all filed amicus briefs. You know, and then you've got thousands, literally thousands of affidavits from XRP purchasers also saying, no, SEC, you got it wrong. Kind of powerful if you're the judge, don't you think? Which is why I'm so appreciative of the judge actually taking the time and allowing all these amicus briefs and taking the time to read and understand what's actually going on here. And I do think that the judge understands the gravity of the situation here. I think that Judge Torres does have an understanding of exactly what's at stake here. Well, at this point, how could you not? And she wanted to make sure that she was armed with as much information as possible. That's, what more could you ask her, right? And then there's this page 21. Excuse me. The SEC has failed to establish or even identify a common enterprise. Although, again, if you're Kim Jong-Ginzer, when you cite the three-factor Howey test, as Kim Jong-Ginzer has called it, you just don't even mention that common enterprise matters. But anyway, here's what Attorney Deaton said. The defendant's opposition brief discusses how the SEC has shifted its theory regarding the common enterprise XRP holders allegedly bought into. In sum, the SEC has struggled to pinpoint a viable common enterprise in this case. The SEC's struggle is understandable, considering the SEC has admitted that it ignores Howey's pesky second prong when applied to digital assets. Indeed, common enterprise. Let's just ignore that thing. And that is what Kim Jong-Ginzer does. And I first saw him do it a little over a year ago. Is that whatever the Aspen Security Forum, I think is what it's called. I think it was August or September of last year. I heard him say three-factor test, I think is how he articulated it. I was like, whoa, the what-a-who? And then I noticed that he just skated on by common enterprises. I was like, what in the ever-loving hell are you doing, Gare Bear? What a silly little Gare Bear. All right, so, so here's an SEC quote. The commission, on the other hand, does not require, and this is important, this is an actual SEC quote. The commission, on the other hand, does not require vertical or horizontal commonality per se, nor does it view a common enterprise as a distinct element of the term investment contract. There you go. They're saying right there, okay, well, common enterprise, yeah, it's part of Howey, but we at the SEC don't think that matters. That's effectively what they're saying. I kid you not. This comment literally on your screen shows that the SEC understands Howey, but that it's not interested in applying all aspects of Howey, which is the same thing as admitting they just don't care about the law. That, as far as I'm concerned, that's the same damn thing. They're acknowledging, they talk about horizontal commonality, vertical commonality, which is really more so just common interest. But, citing again here, the last part of the quote is, nor does it view a common enterprise as a distinct element of the term investment contract. So there you go. They don't like it, so we just don't recognize it. They throw it out. So it's not just Gary Gensler that's not saying it. Maybe it came down from the top. I don't know. So it's not just Gary Gensler that's pretending common enterprise doesn't matter. It's apparently all the attorneys at the SEC. No, we're just going to throw that one out because we're the SEC and we're asshats and we do what we want at our little ass hattery. That's what we do. Screw, law be damned, justice be damned. Don't care who gets harmed. We're just going to do what we want because we're pricks. We're just complete and utter pricks. We don't care. Let's go down to page 22. Right about y'all. All right. The SEC conflates common enterprise with common interest. Yeah, this is one of the things that really burns my biscuits the most, pretending that a common interest is the same thing as a common enterprise. And it's also interesting, though, because they don't seem to think, they flat out states, like, we don't care about common enterprise, effectively, right? But then they'll still go to the trouble to conflate common interest with common enterprise because, what, the judge listening... I mean, what? Guess you hope that you're just going to make her forget that you said the other thing about we don't care about common enterprise, and then just talk about common enterprise and conflate the two, and you're somehow going to get by, and the judge ain't going to catch you there. I guess is that what you're hoping for? Because Judge Torres strikes me as rather intelligent and sharp. I'm just saying. Attorney Deaton continues. It asks the court to substitute the latter for the former. So anyway, substituting common interest with common enterprise. The word aligned appears 22 times in the SEC's brief, but an alignment of interests is not enough to satisfy the common enterprise factor. If the court were to adopt the SEC's argument, the SEC could substitute any cryptocurrency for XRP, and the same argument would apply. Then again, maybe that is the SEC's ultimate goal here, because clearly enforcing U.S. securities laws are not. And I love that so much. That's what I'm talking about. My boy John got the passion, and he's right, and he's right. And it's worth pointing this out very bluntly yet professionally to Judge Torres. It's pretty damn clear the SEC doesn't give a damn. I don't think they're actually quite that stupid. I just think they really don't care, and they're bad people, as far as I'm concerned here. But it's the truth. You just... That's why there's so much at stake here. Yes, XRP holders and all that. Of course, all of us within our XRP community. But every cryptocurrency, with I don't even know what the exception would be under attack. If this skates on by. Maybe they wouldn't go after Bitcoin or okay, fine, and maybe you end up seeing stable coins getting regulated different. But if you're just talking about decentralized cryptocurrencies, you can plug it all in because if common interest is the same as common enterprise, well, holy hell, then we're all in cahoots with everything, everywhere, all the time, in all aspects of life. Okay, fine. That is the dumbest crap. But the SEC is arguing that. So there we are. All right, now let's jump in here. Page 23. Although the SEC admits that Howey, quote, Howey requires courts to look at the economic reality of a transaction, end quote, it does not attempt to establish each Howey factor with respect to any particular transactions. The failure to do so proves fatal to their motion for summary judgment because each transaction, quote, must be examined as of the time that the transaction took place, end quote. Yeah, so let's pause and note, this is something that I brought up so many times for almost 2 years at this point, and I'm so glad that Attorney Deaton is taking the time to talk about this here. Because obviously, look, we all know that the assertion that every single XRP transaction that's ever occurred is occurring, will occur in the future, no matter where or what developments occur. It's all part of this, it all satisfies how it makes it an investment contract, all that crap. Well, we know that's garbage here. But the SEC doesn't have anything better. And if they actually did go after specific transactions, well, then they wouldn't be able to achieve the land grab that I think that they're going for. So even though maybe, and I'm not saying they would, but let's just say, hey, hypothetically, let's say they could win on those smaller, earlier transactions, even if they could, okay. And that's an if still. They don't want something so small. They want something bigger and more than what they jurisdictionally should be presiding over. Right? And then Attorney Deaton continues. Where's the line? Right here. Here we go. More troubling is that the SEC references statements made by the defendants almost a decade ago and then pretends that those statements led or induced present-day XRP purchasers to acquire XRP in the secondary market. And folks, listen up to this because this hasn't been discussed that much, and you may not have heard of this, and it's truly repulsive. But John Deaton is talking about statements made a decade ago, the SEC making the assertion that that impacted effectively present-day XRP holders. So check this out. The SEC literally offers tweets from April 2013 by Ripple promoting Ripple and XRP price increases. However, not one of Amici's 6 individual XRP holders were on Twitter in 2013. The SEC refers to 3 documents from 2013 and 2014 as evidence of an aggressive marketing campaign promoting Ripple and XRP. One example involves the Gateways brochure that was sent to at least 100 people. The SEC has failed to demonstrate whether those 100 or so individuals who actually received the Gateways brochure were led to expect profits from Ripple's efforts, let alone prove anything related to present-day holders. The SEC writes, quote, "In February 2017, Larson and Miguel Villas encouraged an XRP investor to think of XRP's potential appreciation over the long term, including based on Ripple's entrepreneurial efforts," end quote. Arguably, because there is at least some level of privity, communication and contact between Ripple and those identified in those isolated examples, the SEC could attempt to establish each Howey factor with respect to these specific transactions. The SEC does not. Instead, the SEC offers this decade-old marketing material. This is ridiculous. In support of its request to classify every sale of XRP, past, present, and future, as an investment contract with Ripple. There is no evidence that the information Ripple provided many years ago ever reached XRP holders who then considered Ripple or its management team before acquiring XRP in the secondary market. From Amici's perspective, companies unrelated to Ripple promoted XRP much more significantly. Well, ain't that true? So think about this. They're going back to a brochure that's almost a decade, a decade old, and then not even making assertions that this, in what way this actually, or providing proof that it actually did result in somebody purchasing XRP and with the belief that somehow Ripple was some sort of common. No, they're not even arguing that. They're saying because that thing happened, that everything everywhere for all time, endlessly into the future, that represents an investment contract. That's what they're saying. How dumb is that? How did these lawyers pass the bar? That's why, again, I don't think they're stupid. I don't actually think they're stupid. I just think that they're bad people. I just think they don't care. This shows a severe lack of ethics to behave like this and make these, like, how could you possibly? I mean, this is beyond the pale as far as I'm concerned. Harming people to the tune of billions of dollars, yeah. I don't really have patience for that, frankly. Then there's this. Page 25. In sum, the SEC cannot offer this court a single citation in 76 years of case law handed down from the Supreme Court or any federal appellate court within the United States where an investment contract was found when there existed absolutely no contact or privity between the promoter/seller and the purchaser. So think about that. The degree to which what the SEC is arguing, just even set aside how absurd it is and how it's just completely non sequitur logic, even setting aside that, there's no case law for this. It's a novel concept. So they're trying to set some sort of precedent here effectively, and it's why John Deaton, I think, was calling it a test case, to see what they can get away with. That's exactly what's going on. That's why this is so damn repulsive, but it's also so obvious. I don't think Judge Torres falls for this. How could she? How could she? You'd have to be blind as a bat. I don't think she is. I really don't. I think she's going out of her way to make sure she's armed with all the knowledge she could possibly be armed with to make a decision that's going to have far-reaching global consequences. Because that's what's at stake here, and I think she knows that. Then we're on page 27 here. The SEC fails to understand that if Ripple ceased to exist, XRP holders, and companies like Spend the Bits could flourish. In fact, if Ripple's XRP escrow were burned or confiscated, basic supply and demand economics suggest a price increase for XRP, assuming half of the existing supply were destroyed. In short, individual holders and businesses within the XRP ecosystem could benefit in Ripple's demise. And here's a quote from the Spend the Bits amicus brief. If Spend the Bits were to scale, it could, in theory, become a competitor to Ripple's on-demand liquidity system, end quote. Amici are confident in stating that such a scenario certainly does not fit into the common enterprise or joint venture scheme the Howey court envisioned capturing when determining an investment contract. Yeah, so look, if there's a common enterprise, and whether it's Ripple, I mean, it's some sort of weird amalgamous blob that only lives in like the dreams of these little SEC asshat attorneys. Because I'll tell you this, it's not coherent. it's so not coherent, and as a result, if you just think through this logically, if Ripple goes away, and if they're the reason all of this is even happening, then how could it possibly be the case that other participants in any sort of aspect of this ecosystem could continue to thrive? See, doesn't that just tell you right there is no damn common enterprise? Isn't it pretty damn obvious? I think the answer is a clear yes. Let's go down to page 29 now. And and so here I do want to note it first. Like, real people were really harmed by the SEC. And Attorney Deaton brings the point home. Check this out. Start right here. The SEC was well aware that the mere filing of this case would cause multi-billion-dollar losses to innocent third parties. And that comes from the Grunfest letter, which I've cited a number of times over the years. His warning was more than accurate because the damages were more than $15 billion and the disruption of numerous innovative applications of XRP resulted. Buried underneath the $15 billion in losses are real people who have been severely harmed. Not by market volatility, but because, at best, the SEC fundamentally misunderstands the underlying technology, or at worst, has been deliberately misleading so as to arrogate for the SEC optionality as this litigation progressed. And so, accurate statement. My personal opinion is that it's the latter. I don't think that it's mostly, just ignorance on the topic. I think they're mostly sufficiently informed. I just think that their intentions are really bad and they don't care that it harms people. Because it's clear to me that they have looked into certain things, and they're like I keep saying, they're not stupid. There's bad. There's really, really bad. So that's my supposition, is that they're just bad people that just are power hungry and they want to have as much power as they possibly can. That's what it looks like to me. Then there's this. Because of the sweeping allegations, thousands of innocent holders' life savings and retirement accounts are frozen, unable to convert their XRP into Bitcoin, Ether, or USD. Until this court issues a ruling, these XRP holders are unable to access their funds, including if they experience a life-altering event. In the meantime, blockchain innovation has halted at the American border. In truth, the SEC is using this case as a quasi-declaratory judgment to test an implausible theory developed after conducting its own failed Howey analysis. Amen on that. That's why I love this. So this is, again, another thing I was mentioning in my very last video. Like, Attorney Deaton, out of all the amicus briefs, and I think all the amicus briefs are great for different reasons. There's a certain amount of overlap in all of them, but for very, very different reasons, I particularly appreciate them. And one of the reasons that I particularly appreciate this one is Attorney Deaton, more so than anyone else, is talking about the harm done to real people. That stands out, and the judge needs to know this, and she does. Now she does. Unquestionably, she does. John Deaton's made sure of that. This is important. And then jump in here. Attorney Deaton says there are 4,343,575 XRP accounts along with 7,723,297 trust lines connected to the XRP ledger. In other words, there are millions of XRP holders being held hostage as collateral damage while the SEC engages in a jurisdictional power grab. Those innocent holders have been abandoned by the SEC. And here's a quote from Magistrate Judge Sarah Netburn, cited in John's amicus brief. And you may recall this one because this is part of my favorite line ever in this case from Judge Netburn. She said, referencing the SEC here, adopting its litigation positions to further its desired goal and not out of a faithful allegiance to the law, end quote. Bam. And she ended up calling them hypocritical. I love that. It's so obvious for anyone to see. It's even seeping out from the judges who have been professional and in some ways reserved. You know, I think it's fair to say. Attorney Deaton continues. On behalf of the 6 individual XRP holders in their individual capacities, as well as the millions of XRP holders whose interests are embodied in the interests of Amici Curiae, we extend deep and sincere gratitude to the court for allowing and considering Amici Curiae's perspective during this litigation and at summary judgment. After 2 long years of tedious and distressing litigation, a decentralized community of users, investors, developers, and small businesses anxiously await your Honor's decision. Conclusion. Amici Curiae respectfully requests this honorable court deny the SEC's motion for summary judgment because genuine issues of material facts exist. Respectfully, the court should grant the defendant's motion for summary judgment because no reasonable jury could decide in favor of the SEC's exceedingly overbroad theory. Wow. Attorney Deaton, if you're listening, I just got to say thank you so much for doing this. I feel I don't typically feel comfortable speaking for entire large groups of people, but in this case I do. Thank you from all of us, from everybody in the XRP community, because I know we all feel the same. You are doing an amazing job. I hope you're listening, and thank you so much for what you've done. This is absolutely incredible. I hope I did this justice in this, two-part video thing that I just put together here. But we could not be more thankful. And you really did an absolutely fantastic job. And it's so powerful. It's so powerful, making clear the harm that was done, artfully pointing out, with clear passion, which I think matters because we're all humans in the end, but pointing out the degree to which the SEC is not using logic and arguing the things that they logic. Their arguments fall apart. And those are a couple of things that just really stood out to me in reading this amicus brief. It's powerful stuff here. I'm very optimistic that justice is going to be done. It's ultimately up to the judge here, but she is armed with the knowledge she needs to make sure that this innovation can persist in the United States indefinitely into the future, and that justice is done, for XRP holders and everybody else participating in the entire crypto space. And so there's a lot at stake here. But I mean, I'll tell you what, if things don't go well for us after all of this, these 10 amicus briefs and Ripple's arguments and everything else, it's not for lack of trying, and it's not for lack of sufficient effort and sufficient arguments on the side of XRP holders. I'll just say that. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.